Without any further ado, please join me in welcoming Rodney K Smith.
As they're hooking up my PowerPoint, I will do a little connection between my work in the constitutional area and in the sports law area that I would often say, like, much like Professor Bibby said, that people have asked me, well, how could you be in such areas that are so diverse? I said, well, I'm particularly interested in religion and religious liberty, so why wouldn't I be interested in the religion of the American people, sport? So that's true. The other thing, I played basketball in college, and I know Professor Bibby had suggested people moving together, but it's clear to me that you want to exercise your right not to. And I'm also, so you're I don't have the peripheral vision to see you all, but I'll respect your right to sit where you will.
You got one convert.
Thank you. I don't know if it's not up, so I'm just going to start with a picture. This picture has 5 individuals in it. And I don't know that the picture's going to come up. I don't know that this PowerPoint's going to work. I'm old school. I almost never, I didn't use a single PowerPoint in my American Heritage class here. And this is why. That invariably there are issues that arise. So I'm just going to go ahead and jump in, and you're not going to get to see the pictures. Hopefully if they show up, I will get back to them. I'm really going to begin in my address and take you through a history, a snapshot of the history of religious liberty, particularly the Free Exercise Clause, up through the present status of RFRA. The person who is respected as the father of the Constitution, although no one deserves that title because it was so collaborative, and also father of the Bill of Rights, now he may well deserve that, as James Madison. I'm going to begin with James Madison. I'll begin with him at the stage that many of you are at. Or close to it. He has just finished college at the College of New Jersey, which is today Princeton. And he has returned home. And he's returned home to something that vexed him more than all else. And that was, he returned to see the right of religious conscience being trampled upon in the state of, or was it in the state, in Virginia, in the colony. And he was deeply concerned about that issue. He then, and this may happen to some of you too, he becomes depressed. He doesn't know what to do with himself. He hasn't found an occupation. And then he slowly begins to get involved in public life. And then, while not much older than many of the youngest students among us, he is selected as a delegate to the Constitutional Convention and goes to work on preparing a Declaration of Rights for Virginia. And in his suggestion, which isn't fully adopted, he says, among other things, the following. He said, religion, or the duty which we owe to our Creator, and the manner of discharging it being under the direction of reason and in conviction only, not of violence or compulsion, all men are entitled to the full and free exercise of it. according to the dictates of conscience. So for him, it was what he called the right of religious conscience. And everyone was entitled to the full and free exercise of it. For him, it was an inalienable right, literally a gift from God, and existed prior to the organization of the state. And as such, no just state, in his view, could take away this right. He then said there are two conditions, but only two conditions in his proposal, when the state may limit the right of religious conscience, the right of the full and free exercise of religion. And that was one, in the preservation of equal liberty. In other words, if you have one religious liberty right up against another religious liberty right, then obviously the state has to become involved in some way. Now, he felt that that province really belonged to the court. So equal liberty as to rights of conscience. Then secondly, they could get involved when the interests of the state would be, his language, manifestly endangered. In other words, the only time you could take this right was when, or the state could act against this right, was when the equal liberty of another was implicated, or alternatively, when the existence of the state would be manifestly endangered. Now, his reasoning for that's obvious. No one would have a right of conscience if, in fact, the state was manifestly endangered. So it was a very, very strong provision protecting religious liberty. He then, we'll jump forward to the First Amendment. My children and now my grandchildren will often joke. They'll say, what does Grandpa do? And the word in our family is he's trying to figure out what 16 words mean. Those 16 words are, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, it is today the First Amendment. There were actually 12 amendments. The first two were more procedural, but this was the first substantive amendment that was adopted and then ratified by, as part of the Constitution. So it is the First Amendment, the first substantive amendment, and the first substantive portion of it is, Congress shall make no law respecting an establishment of religion. We're not going to talk much about that. For Madison, again, that was an equality kind of principle. Or prohibiting the free exercise thereof. Then the very strong language prohibiting was used intentionally. As you go through the debates, you'll see that they're often saying things like, the government may not even touch on religion. So prohibiting is this strong sort of verbal form. And then it goes on and then it says, or abridging, which is a weaker term, and then goes on to speak about the freedom of speech, press, so forth. So again, what really has happened in the First Amendment is they have largely adopted Madison's view. Madison then, shortly thereafter, after the ratification, and within 2 months of it being sent by Secretary of State Jefferson to the states, writes an essay on property where he goes to pains to explain this right of religious conscience that has been protected in the First Amendment. He indicates we have rights in our property. Now, we all understand that. If I come and take somebody's computer away, you're going to say you're taking away my property. So we all have rights in our property, but he said we also have property in our rights. And he was telling us something fairly profound about this First Amendment and about this right of conscience. My right of conscience, yea, even my right of expression, are reflective of me. They are part of who I am. And when the government takes that from me, particularly when they take the right of conscience, they're taking that which is most precious. In this essay, Madison referred to conscience as the most sacred of all property. Sacred means set apart, special. And he did the same thing in his report on the Virginia Resolution. He talks about this inalienable right and its importance. But think of it as property. So when the government takes it, they're taking that which is most intimate, most significant in the life of the believer. So he then goes on in this essay and he says, now we have a takings clause that says you can take property when? When may you take property? Government may take your property, your real property, when? Was there no? No one's ready? Yes. Well, that's close, but I really think we should use the exact words, which are just compensation. And that compensation, you can pay for that. So if you want to take, if the government wants to take my house and use it for another purpose, they have to justly compensate me for it. But what about our rights? If they take my right of conscience, how would they compensate? We can take your house and pay you money, right? How are you going to compensate me for taking my right of conscience?
Your PowerPoint is working.
Oh, my PowerPoint's working, but I don't have the thing to move it, and we're into this anyway, so I will come back to this in a minute. But what do you do about taking of that? How can I be compensated for taking my conscience? That you can't, there's no monetary figure for that. You're taking that which is most sacred. And so Madison, that was the Madisonian position, and that was, and he indicated repeatedly that the Bill of Rights were widely agreed to. Oh, do we have a clicker?
Yeah, it's not showing now, though.
Okay, well, all right. See, there you have
Clicker
it.
works. Here we go. Here you go.
So, there, which one do I click? This one to go forward?
Forward, yes.
So that's his own property. See, I really did have this here. And then, now we're going to get to, Morrison Waite. Morrison Mott Waite is confirmed to be the Chief Justice of the Supreme Court during an important part of our nation's history. Chief Justice Morrison Waite is pretty obscure. People don't even know who he is he and most of the members of the court do not have what today we would call a theory of constitutional interpretation. In fact, his ended up being quite odd. He believed when Congress passed the Reconstruction Act, the Reconstruction Acts which were to enforce the 14th Amendment and equality, that the court should act in a very restrained manner. But when religious liberty came up, without reference to Madison or to this rich history of the public meaning at the time of the ratification, he relies on his own wisdom, and his own wisdom was polygamy's not really religious, it's evil. And the state has every right to do that. So he, when it came to that most sacred of all rights, he says, and the court with him, well, we can go ahead and take that. But as to Reconstruction and equality, he limits that. So he's really flip-flopped on the founding. And there are three cases. We're going to hear more about Reynolds in particular. That's the first. But the other two are significant. Davis versus Beeson. The Latter-day Saints don't relent after Reynolds. So they have to tighten the noose. So they decide they'll take away the right to vote of anybody that even believes in polygamy, whether they practice it or not. The Wake Court, fine. The state may engage in that. So they're not only taking the right of conscience, now they're taking their right to vote. But still the Latter-day Saints don't relent. So, in the late Corporation of Latter-day Saints, they said, okay, we'll take your property. We'll take away your corporate status. And they did. And then you have some movement on the part of the court, that the Latter-day Saints then relent. Then let's jump forward to Earl Warren. Earl Warren's a little bit like Wade. He doesn't have much of a theory of constitutional interpretation, but he does have this theory. His theory, and the theory of the Warren Court, was essentially liberty, this is a quote, is the most contagious force in the world. Then he said, our Bill of Rights, the most precious part of our legal heritage, is under subtle and pervasive attacks. When the rights of any individual or group are chipped away, the freedom of all erodes. Okay? And his theory is the court's uniquely situated to protect human rights because it's insulated from the tyranny of the majority. And so the Warren Court is known as a very libertarian court. And he now revives a test that's reasonably close to the Madisonian test, which is that there has to, before a government can take this right of conscience, they have to have a compelling interest, and it has to be narrow, and the manner in which they apply it has to be narrowly tailored. This was a right that widely respected the right of conscience. And it was opposed to direct or indirect takings, which was, again, something that Madison made clear in his essay on property. So he's revived the test, essentially. So then we move to Justice Scalia. Now, I wanted to put up the first picture, and I was actually going to give it a surprise. How many of you, how is Justice Scalia on religious liberty? Invariably, conservatives think, oh, he was wonderful because he's he's almost an icon. We almost worship him. He did more to harm religious liberty than any single justice who sat on the court in my lifetime. He said, I don't like he didn't even pay attention to the Madisonian standard. His theory was, I'll look at the text, and then I'll read the text, and then I'll defer from the text and give power to the states in particular. So in Oregon versus Smith, he sets up a new test, which says a government could take it as long as it does so neutrally, as long as it's not saying, I'm going to take your religion, but not yours. Or it has to be in a neutral and sort of a generally applicable legislation. But it clearly permits for the taking of religion. And then, how about this person? How about William Jefferson Clinton? Pro or not pro religious liberty? Huh? Pro. The most pro person in my lifetime. I once introduced him, and I introduced him and thanked him for his support of RFRA, and the purpose of RFRA, which we're studying today, was to restore the Warren and somewhat Madisonian standard and to protect religious liberty. And I told him that. I introduced him, and he came up to me afterwards, and his eyes are glistening. And he said, "Rod, what you said is absolutely true. I care so deeply. But sometimes people think, given the life they believe I've lived, I couldn't possibly be the strong proponent I am." But he was, and they passed the Religious Freedom Restoration Act, and Professor Bibby explained why that was so, how that was received, and the ceremony on the West Lawn. And then what happens? The court responds. And they respond in City of Bernie versus Flores, in which it's a 6-3 decision. It holds that Congress doesn't have the power as to the states to restore this standard, only as to the federal government. And today we spend much of our time determining what it means as to RFRA as to the federal government. Although 21 states have adopted it, 21 states have restored religious liberty. Utah is not among them. It has a bit of a hybrid. Why don't they? Why wouldn't they all want religious liberty? Well, I think we're going to hear a lot more about that from Professor Istook. Is that right?
Yeah.
And you're going to hear more about the history and the philosophy from our next speaker. So I will conclude with this. If you don't remember anything else from this, remember this: that when you take someone's duty to God, when you take their religious liberty, you cannot compensate them for it. And you have made an act, you have been complicit in an act that vexed the father of the Constitution and the Bill of Rights, James Madison.
Thank you for that presentation. And I'm grateful for the opportunity that I have to be here at this conference. I think you'll find that both the substance and manner of presentation for my presentation will be substantially different. So I'm eager to get into the conversation so we can have hopefully some fruitful debates and conversations about this. So the title for my remarks are Reynolds, Smith, and the Inevitability of Modern Liberalism Supremacy. Let me begin by offering some general notes about my general thoughts on the First Amendment's Free Exercise Clause that I hope will frame my general remarks. Number one, I think that the First Amendment's Free Exercise Clause provides protections for religious practice that go beyond protections for mere opinion on all matters, political, religious, or thoughts on the quality of the new Star Wars films, whatever it might be. We all have thoughts that bounce around our heads on these subjects and many others, and they do not require a specific clause in the Constitution to protect them. Number two, I think that it is impossible to understand the First Amendment's Free Exercise Clause apart from one, the understanding the founders' liberalism, and two, the indispensable role that religion, namely Judeo-Christianity, played in securing the goods of the moral order that helped foster Republican virtue, as well as stable government. Religious practice is protected in the Constitution not simply because it is a liberty interest akin to skiing, playing basketball. Rather, I believe that George Washington, that he captured the general American sentiment of his time, and of the time when the First Amendment was adopted, when he said in his farewell address that of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness, these firmest props of the duties of men and citizens. And let us with caution indulge the supposition that morality can be maintained without religion. Whatever may be conceded to the influence of refined education on minds of peculiar structure, reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. So with that by way of introduction, I'd like to present my thoughts on the beginnings of the country's free exercise clause and its jurisprudence in the 1878 Reynolds case, which, as mentioned, dealt with Mormon polygamy. I want to deal with what I think it gets wrong, what I think it gets right, and why I think the holdings in Reynolds and the similar 1990 Smith decisions are correct. And in this regard, we'll see substantial disagreements between my presentations and that of Rodney Smith. I should be quick to add that even though I disagree with the Reynolds' use of legislative history, I do think that, again, as I said, I think the holding is correct. Finally, I should mention that I am a political philosophy professor, and so my aim is not only to address what in these decisions I find to be constitutionally correct, but also which ways of thinking about religious liberty and church-state relations support the goods of liberalism, peace, basic moral order. So just to give a little bit of an introduction to the Reynolds case. I had the opportunity about 4 years ago when I was working on my book project. As was mentioned, I have a forthcoming book that is on the moral political development of the American idea of marriage. This brought me back to studying Reynolds, and this was around the time of the 2014 Hobby Lobby case. As I was reviewing these cases, I became impressed not by how much the court's understanding of the principles governing the free exercise clause has changed over time, but rather how much the doctrine set forth in Reynolds matches the principles now governing the court's free exercise jurisprudence. Indeed, the court's valid and neutral law of general applicability principles set forth in Smith by Justice Antonin Scalia, it uses the same animating principle in deciding which statutes violate the free exercise clause that Reynolds used. Indeed, this is how Scalia paints his decision and the court's decision, not as a departure from the court's jurisprudence in Sherbert, but rather the continuation of a long line of precedent that began with Reynolds. Further, it was evident to me that the same constitutional doctrine that was used in 1878 to strike down the second relic of barbarism was used in 2014 by the Obama administration to mandate that a closely held corporation with an explicitly religious purpose provide its employees with abortion-inducing drugs, contrary to their religious beliefs. To be sure, there are significant differences between the Reynolds case and the Hobby Lobby case, namely the presence of the Religious Freedom Restoration Act, which was ultimately decisive for the court 4 years ago, and the fact that Hobby Lobby dealt with administrative regulations rather than congressional statutes. Similarly, there are differences between the two cases that I'll focus on today, Reynolds in depth and then Smith more briefly. Notwithstanding, my argument is that the principle laid out in Reynolds and Smith are not only rooted in a correct understanding of the First Amendment's free exercise clause, but that they are also inevitable given the logic of liberalism. That basic principle is this, that religious exemptions or counteracting balancing tests to valid, neutral, and generally applicable laws are not incorporated into the First Amendment, though they may be appropriately brought about by legislative or executive function. The holdings in Reynolds and Smith are true to the understandings laid out by James Madison and Thomas Jefferson. Here, with Madison, the key test being the non-cognizance test. I also think that it is true to the understanding laid forth by George Washington, who had arguably a more favorable view to religious free exercise. I would also argue that it is true to the thinking of every major legal treatise writer in the early 19th century, how they understood the original intent of these clauses. Still further, the logic of Smith and Reynolds is, for the most part, the logic of John Locke, the logic that he outlines as a principle that must animate all church-state relations. The logic of the Smith case is the logic of liberalism, and it is inevitable in all liberal regimes. I mean this in the broader view, in terms of John Locke's liberalisms rather than Nancy Pelosi's. The logic of even an admittedly friendly liberalism in this regard can be stated briefly. While religion may be a real private and public good, its claims on adherents' actions cannot subvert the state's power to prescribe and proscribe citizens' behavior for valid and reasonable public interests. If this were not true and the state could not apply valid criminal statutes equally to all its people, the state would not be sovereign in its own territory, but rather controlling religious dogma. So, by way of background to the specifics of Reynolds, given that this is a conference on religious freedom at Utah Valley University, I may not need to go into as great of detail, but nevertheless I will give a brief accounting of the facts of the case. So the 1856 Republican Party platform famously coupled slavery and polygamy as the twin relics of barbarism, and committed the party to prohibiting these practices in U.S. territories. The 1862 Morrill Act outlawed polygamy in the territories, and local Utah officials refused to enforce this law in Utah. This prompted Congress to pass the 1874 Poland Act, which added necessary muscle to the Morrill Act and gave the federal government the prosecutorial tools necessary to enforce these laws. Soon after the Poland Act passage, several Mormon leaders recruited Brigham Young's secretary, George Reynolds, then a monogamist, to take a second wife in order to test the enforceability and the constitutionality of this law. Reynolds was soon arrested and convicted at trial on the basis of his second wife's testimony, and the decision was reversed on appeal on procedural grounds before Reynolds was convicted again at retrial, after which the case reached the Supreme Court. Reynolds' attorney, a prominent Philadelphia lawyer, George Biddle, argued that Reynolds' polygamy ought to be protected by the First Amendment. The Constitution, he argued, separated acts that were mala in se, or intrinsically morally wrong, and acts that were mala prohibita, things that were wrong only by convention or legislation. Biddle suggests that acts that were mala prohibita were protected under the First Amendment, while those that were mala in se were not. Bigamy, Biddle said, was not prohibited by general moral code, or certainly not by the Ten Commandments, or general view of the Old Testament and the Bible as a whole. I mention this aspect of Biddle's argument only because I think that Justice Waite's opinion for the court only makes full sense if we understand how the court understood the nature of the wrong of polygamy. While Waite and the courts do not accept Biddle's argument about the First Amendment's protections for actions that were only mala prohibita, Waite nevertheless deems it necessary to argue that polygamy is wrong according to the law of the land and the moral order. In this regard, I would argue that Waite's argument is not that polygamy is deserving of protections that fall under the Free Exercise Clause, but rather that there's a compelling interest for laws prohibiting this. Okay, in this regard, the Reynolds decision is first and foremost devoted to a moral political philosophy and only secondarily focused on religious free exercise. Writing for the court, Chief Justice Morrison Waite says that religious freedom demands that government not legislate the field of opinion or religious belief, and even certain aspects of religious practices or behavior. However, he is quick to argue that it is time enough for the rightful purposes of civil government for its officers to interfere when principals break out into overt acts against peace and good order. What belongs to the state and what belongs to religion is the key question in Reynolds. No matter what the First Amendment's free exercise clause means, the court is convinced that it cannot obviate the state's power to secure peace and good moral order. Quoting again from Waite, "Man has no natural right in opposition to his social duties. Likewise, Congress does not have the right to legislate mere opinion or religious dogma, but it retains full power to reach actions which were in violation of social duties or subversive of good order," close quote. Note how the court addresses Reynolds' violation and conviction. It does not simply say that Reynolds broke the positive law and that therefore his conviction should be sustained. Waite could have done this, and he could have done this in less than a page. And the decision would have read something like this: "The United States law is supreme in all of its territories, not any precept of Mormon doctrine or commandment. U.S. law prohibits the practice of polygamy, and therefore all violations of this law may be duly prosecuted, including that of Mr. George Reynolds. End of story, period. It is so ordered." The court, however, makes an argument that polygamy is not only illegal, but that it is illegal because it is a moral harm and subversive to liberal Republican government. Waite's opinion finds roots in precedent as well as in the idea that polygamy threatened liberal government. Polygamy, he says, has always been odious among the northern and western nations of Europe. Polygamy was outlawed by English common law and punishable in all American colonies and states from the earliest days. It had always been deemed incompatible with Western morals and Republican government. Waite insists that this tradition against polygamy is grounded in reason. By nature, he says, marriage is a sacred obligation, and yet it is a civil contract in most civilized countries. Echoing prominent founder James Wilson's lectures on laws, Waite says that marriage is the foundation of society and the source of man's social relations and obligations. It is in the family that man learns society's order and the responsibilities he bears in it. For this reason, the court says polygamy is especially harmful to children who are raised in perverse familial relations and to women who are often coerced and subjected to marriage. Though Waite does not explicitly address Biddle's argument that the Constitution protects religious acts simply wrong because of congressional law, this portion of his argument clearly shows that the court thought polygamy was malum in se, or that it was something intrinsically harmful to the liberal order, and thus that the prohibition of polygamy is a legitimate state interest. So why this argument about marriage's nature and its relationship with Republican government? Why come down so hard? While Waite recognizes the supremacy that the positive law grants the state, he knows that this power is dangerous unless qualified by the natural law and used based on such principles. Likewise, Waite reminds us that religion is not always benign. Indeed, not all religious practices are equally amenable to liberalism's natural rights theology. Waite says, suppose one believed that human sacrifices were a necessary part of religious worship. Would it be seriously contended that the civil government under which he lived could not interfere to prevent a sacrifice? Or if a wife religiously believed that it was her duty to burn herself upon the funeral pile of her dead husband, would it be beyond the power of the civil government to prevent her carrying her belief into practice? If the answer is no, the court argues, we've admitted that the state is not sovereign, that the people and its laws are not sovereign. Rather, we've admitted that there are millions of sovereigns across the country, as numerous as there are conceptions of God and the demands he places upon us. That they are sovereign even if they violate rights, harm Republican order, or threaten other public goods. To admit this is to argue that the First Amendment intended a religious subversion of the liberal order and the good it secures. Or, as Waite argues, to permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself, Government could exist only in name under such circumstances. When we look at the actual decision in Reynolds, we see that the court effectually incorporates James Madison's memorial and remonstrance into the First Amendment's free exercise clause, along with Thomas Jefferson's letter to the Danbury Baptists. I think this is a mistake. I think this is a mistake that affects later jurisprudence, including several establishment cases like Everson. But I do not think a correct understanding of the clause would have changed the holding in this, the Reynolds case, or the Smith case. As Donald Drakeman convincingly shows in Church, State, and Original Intent, Waite and subsequent jurists neglect the thought of dissenting Virginians such as George Washington, and more importantly, every legal treatise writer from the early to mid 1800s. Joseph Story, Joel Tiffany, George Pascal, John King, all differed from Madison's non-cognizance test and Jefferson's Wallace. Notably, the eminent Joseph Story said, probably at the time of the Constitution and of the First Amendment, the general, if not the universal sentiment in America was that Christianity ought to receive encouragement from the state. So far as was not incompatible with the private rights and conscience and the freedom of religious worship. An attempt to level all religions and to make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. Story later adds, the right of society or government to interfere in matters of religion will hardly be contested by any person who believe that piety, religion, and morality are intimately connected with the well-being of the state and indispensable to the administration of civil justice. The First Amendment's religion clauses elude simple interpretation, but I think the Story's interpretation comes closest to capturing the general sentiments of those who adopted them. Further, while it remains difficult to understand how these principles would apply in all religion cases, I do think that it is clear that no prominent founder or legal treatise writer of the period thought that the Free Exercise Clause provided accommodations for indirect burdens resulting from violations of criminal law, or provided any sort of balancing test as being a part of these religion clauses. Is it possible for legislatures to provide principled tests, as is done in RFRA, to further buttress religious freedom? Absolutely. And I think Congress was correct in passing RFRA in 1993. Is it possible for legislatures to allow some accommodations in law? Yes, though I think they should be careful in doing so. Justice Antonin Scalia cites Reynolds in the court opinion in Smith, and he follows the logic of liberalism that I've laid out here. The Smith case, like the Reynolds case, highlights two important and unchanged truths about religion's relationship with liberalism. First is that religion and liberal regimes only flourish simultaneously to the degree that both are reasonable. Waite recognizes this, and thus he gives the court's opinion not only in the language of the positive law's strength, but also in the language of the moral order. Second, religion and liberalism are only compatible, to the degree that the latter is limited in its ambitions. In short, the broader the government's reach, the more areas of life where religious freedom will be necessarily preempted. To the degree that the principles of Reynolds and Smith may be used to erode religious liberty, I believe this is a sign of politics and a culture that fails to see religion as a positive good that limits government's own actions. In such a setting, a healthy religious freedom cannot long survive on parchment barriers, constitutional or statutory, as in the case of RFRA. Legitimate and necessary as I think these things are, the logic of liberalism in the expansive secular state will eventually swallow it whole. A healthy religious freedom is inseparable from a broader culture that sees and protects the good of religious freedom, indeed the good of religion. To the degree we lose the latter, we will inevitably lose the former. Any demos persistently claiming a public interest will eventually get its way. The legal supremacy of the liberal secular order is inevitable. Thank you.
Good morning. Most of the students at UVU were not around when the Religious Freedom Restoration Act was adopted back in 1993. So to kind of explain why we're here, I think it's necessary to look back a little bit at that era for those of us who, lived through it and have a little bit of gray hair to show for that. Now, this legislation, the Religious Freedom Restoration Act, essentially says if you have a government law or policy that substantially impairs somebody's free exercise of religion, then the government has an obligation to show that it has used the least restrictive means in imposing that policy to minimize how it might impair religious freedom. That's the essence of this statute, which is now 25 years old. And it is law, remaining law, on the federal level, although the U.S. Supreme Court, as Dr. Smith mentioned, has said, now this does not restrict the states. Congress only had the power to restrict federal policy, which is why some 21 states have adopted state-level versions of this. Now, why was this done? Back in the 90s, we had several things that have been going on that concerned people. On the Religious Freedom Restoration Act, there was a particular court decision. The facts of it really don't matter, but it concerned people that the courts were going to use a very broad interpretation that would allow government policy to impair the free exercise of religion. Therefore, this law saying you got to use the least restrictive method possible. And it has to be a law that's general application. It cannot be aimed at religion. But it wasn't the only thing going on. We had what had happened with the courts in Hawaii and later in Vermont, basically beginning the policy of courts saying there is a constitutional right to same-sex marriage. So in this same general era, Congress adopted the Defense of Marriage Act, DOMA, which said for purposes of federal law, marriage is only between a man and a woman. Now, if states want a state law that differs from that, they can make it effective only in their own state boundaries, but they cannot, that's not going to be entitled to require other states to give some sort of recognition or full faith and credit to that. And then the third thing that was going on that era, which I was most involved with personally, there'd been a whole series of cases, basically known as the school prayer cases, that were restricting what could be done in school settings, or for that matter, on other parts of public property that involved prayer or other religious expression. So we had all these things that were going on in that era. Now, today, the culture has changed very much since then. This Religious Freedom Restoration Act, which was unanimous by voice vote in the House and had only 3 nay votes in the Senate, would have a very difficult time getting passed today because the culture has changed. We've had several tipping points in that. And the notions of religious freedom have been narrowed in this, which is a fascinating thing. I mean, just take for a moment, let's analogize with the school prayer cases. Normally speaking, when you are on public property instead of private property, your rights normally are broadened because you don't have a private property owner just say, you are limited in what you can do on my property. However, when it comes to religion, the fact that you're present on public property is used to minimize what your rights are. In some of the school prayer cases, Supreme Court Justice Potter Stewart said that if you have a law that requires a student to go to school, and while they're there, they're required to abstain from what is normally religious expression anyplace else, then you've placed religion at an artificial and state-created disadvantage. Former Chief Justice William Rehnquist, in a dissent in one of those cases, Wallace versus Jaffrey, said, courts quit using this phrase, separation of church and state. It's not in the Constitution. And in Justice Rehnquist's words, it causes a mischievous diversion from what the First Amendment actually says, and what the Founding Fathers were actually doing. Now, think about that. If the requirement is a total separation of church and state, then as government expands and takes up more space in our lives, religion is required to shrink. The Constitution doesn't say anything about separating them. But these were the underlying philosophies. So, as the different efforts were made back in the 1990s, the Defense of Marriage Act, which has now been struck down by the U.S. Supreme Court, the Religious Freedom Restoration Act, which has been limited by the Supreme Court to policy, but not there. And my own effort was the Religious Freedom Amendment, which sought to address a number of things. But here's the catch. When we talk about restrictions that are being imposed or culture changes, we have decisions from courts that say this is dictated by our interpretation of the Constitution, even if that interpretation may be backed up only by a 5-4 decision on the U.S. Supreme Court. So this has constitutional standing. But when we say these solutions are going to be based upon just statutes, which can themselves be declared unconstitutional, you have a disparity between what the nature of the problem is elevated to a constitutional level and the solutions are down here on a statutory level, which are inferior, because the Constitution is going to trump any statute. This has been going on for many years, with the culture changing. And ironically, when the Religious Freedom Restoration Act was adopted, it was trying to get ahead of what they thought would be a series of court decisions. Today, threats to free exercise of religion are much greater than they were in 1993. And that demonstrates to me that more than ever, we need the Religious Freedom Restoration Act, as well as attention to other religious freedoms. Would you hand me my water for a moment, please? Thank you. Now, this has come about by creating a conflict between two important concepts of rights: religious freedom and sexual freedom. Because the mechanisms used to try to attack or limit the Religious Freedom Restoration Act are saying, oh, wait a minute, you cannot use this to limit findings on same-sex marriage or LGBTQ rights and so forth. And the people who have fallen off the bandwagon for the Religious Freedom Restoration Act, if you read what they say as to why, it's because we believe we have to respect constitutional rights of same-sex movement, which are more important than religious rights. But it not only is a question of sexual freedom versus religious freedom, it also becomes a question of rule of law. We have an explicit constitutional provision in the First Amendment not to interfere with the free exercise of religion. We do not have anything mentioned in the Constitution regarding sexual behavior. But we have different Supreme Court decisions that relate to that, obviously with abortion laws and with same-sex marriage and so forth. But the claim is being presented today that the rights that we believe are inherent rights that are not mentioned in the Constitution get priority over rights that are mentioned in the Constitution. Now, our Constitution does not claim that all possible rights are expressed in the Constitution. That's in the Bill of Rights, back in the Ninth Amendment in particular, and the 10th Amendment too, plus in the Declaration of Independence, where Thomas Jefferson wrote, "All men are created equal, endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness." And the Founding Fathers believed that rights did not come from government, they came from God. And whether government gives you a right or not doesn't mean you don't have it. So are the ones which courts find to be inherent superior to those that we have made explicit. That is why the concept of rule of law is at issue in this challenge that people face. If we are going to say that things that are explicit in the Constitution can be overcome by something that courts decide exist and have a higher priority than the ones that we have already agreed upon and enshrined in the Constitution, that judge-made law is superior to the written Constitution, that becomes a threat to rule of law itself. And furthermore, if you look at what's happening, because as the culture changed, many of the people and organizations who originally supported the Religious Freedom Restoration Act, which was adopted almost unanimously, are now saying very different things. For example, the principal author of the legislation in the House of Representatives was then Congressman, now U.S. Senator Chuck Schumer, who is the Democrat leader in the U.S. Senate today. Now, after the Hobby Lobby case, where the Supreme Court, on the basis of RFRA, said that a closely held corporation, which was doing business as a subchapter S, not publicly traded, but closely held corporation, is still identified with the individuals and they retain their religious rights, and the Religious Freedom Restoration Act means that government cannot interfere with that and require them to do contraceptive means or abortifacients that are contrary to their religion, because it's a closely held family business. No matter how big it is, it just involves a handful of owners. Well, after that came out, Senator Schumer condemned the case, and just to share with you some of his words in supporting the legislation to undo now RFRA, he basically said that people have to choose between exercising their religious rights and doing business. As Senator Schumer said, we wouldn't tell the owners of Hobby Lobby to convert to a different religion or disobey the religion, but we don't say that they have to open up a company and go sell toys or hobby kits. That you have to surrender certain other rights if you insist on exercising your religious rights. And indeed, if you read the briefs that were filed by the Solicitor General on behalf of the Obama administration in the Hobby Lobby case, you will find that the contention made by the government was, whenever somebody is engaged in making a profit, they must surrender some of their constitutional rights, and specifically First Amendment rights. That if you want to be engaged in profit-making activities, you must surrender First Amendment rights. That's in their briefs. Now just extrapolate that, not only on religious freedom, but I think most of the, even though they sometimes fail to do it, most of the major media news outlets are designed to be profit-making. Does that mean they have to surrender their right of free speech or freedom of the press because they're trying to make a profit? And the profit motive taints constitutional rights. That's the contention that not only was in the briefs from the Solicitor General in the Obama administration, but is being pushed by many other groups today. You know, if you do not do the things that we want, we're going to drive you out of business. And certainly there are cases before the U.S. Supreme Court right now that relate to that. So it's not just an attack on the free exercise of religion. It's an attack upon the rule of law. It's an attack upon someone trying to make a living or to actually be an entrepreneur as opposed to just an employee. That's how broad the attack is. And that's how much it's gotten the field. And the rhetoric You read things, for example, like from the ACLU, which originally supported the Religious Freedom Restoration Act, and now they say, oh, this is being used as an excuse to harm people in the same-sex community or in others who might be discriminated against. And the legislation that is currently pending, and it's been filed in many different forms, but the one currently pending is called the Do No Harm Act. Joe Kennedy being the principal sponsor of that, with some, I think it's 118 co-sponsors who all happen to be Democrats. There are no Republicans that are co-sponsors on the HR 3222, Do No Harm Act. And it says in its provisions that everything in the Religious Freedom Restoration Act that requires government to use the least restrictive means for anything that might interfere with freedom of religion, but it doesn't count if it involves the Civil Rights Act of 1964, the Americans with Disabilities Act, the Family Medical Leave Act, Executive Order 11246, the Violence Against Women Act, the Department of Housing and Urban Developers rules entitled Equal Access to Housing and HUD programs regardless of sexual orientation or gender identity, and the religious protection provisions also don't apply if it involves employers providing wages, other compensation or benefits. Does not apply if it involves collective activity in the workplace or protection against child labor, abuse, or exploitation, or access to information about, referrals for, provision of, or coverage for any health care item or service. And it goes on with a couple more ways, and they want to create so many carved out exceptions to say that government can interfere broadly with the free exercise of religion. And again, it's not exclusively so, but it typically has been framed as a debate between religious freedom and sexual freedom. Now, there's no need to have that particular conflict unless you are intolerant of someone who disagrees with you. And that's what's being framed. This is the situation as I see it. It involves the cultural changes that are dramatically different from what the culture was in the United States in 1993. We've had a lot of tipping points that have happened in my lifetime. Go back to the 1960s with assassinations of a president and other people, a lot of civic unrest, campus unrest, riots in different places. We've had the growth of mass media, which allowed the culture which the media promoted to displace opposing values. And certainly we've had a growth in judicial activism and a tepid response from a lot of lawmakers. Rather than saying a constitutional declaration or abuse by a court requires a constitutional response, whether it be elevating the proposed remedy to a constitutional amendment or using the ability to impeach judges. Most impeachments in American history have been of judges, not of any other office holders. But lawmakers have been behind the curve, and unless you take a constitutional level response, which is certainly what I chose to do with the Religious Freedom Act, which was voted on in the House in 1998. It got a majority vote, but not the requisite 2/3. But unless people who are in positions of responsibility make a response that's commensurate with the level on which opponents are acting, enshrining certain things beyond the reach of the public, beyond the reach of normal legislation, by saying this is a constitutional mandate and therefore you cannot touch it. That's the challenge that we deal with. I hope that's helpful to you to have some understanding and perspective of what we're dealing with. And it boils down to the question, what manner of people do we want to be? And do we want an orderly system of governance which allows the people to be sovereign not any group of elites, whether they be a president, a senator, a Supreme Court justice, or anyone else. It boils down to our ability to govern ourselves. Thank you.
Thank you. Thank you. Ernest, just as a reminder, our next panel will start at 10:35, let's say. 10:45. 10:45, thank you. We're now going to open it up to questions. We have about 10 minutes for questions. We'd like to give students the opportunity to ask the first question. So at this point, we're just going to send a microphone around. Please wait until the mic reaches you. Are there any questions for our panelists? It does not have to be a student.
I always have questions.
Okay, so let's give the mic over here to Carl.
Hi, Carl Scott, Center for Constitutional Studies. You'll see me later today. Brandon, could you say a little more about your title and the stuff at the very end about the kind of inevitability of the march of liberalism? I just want to get a little more clarity of where you're coming down there. I mean, recently, Patrick Deneen said, liberalism has failed. What's the extent of your commitment to liberalism? Isn't it really determining the culture? So, what's the answer?
Yeah, so the fact that liberalism is inevitable in that regard, I don't think is a good thing. I mentioned at the end that one of the key problems that we see is that the larger the state becomes in a modern secular liberal order, there's just more room where you can have encroachment, more problems, places where religious freedom is encroached upon. And there is, I think we have to admit, only so much that statutes can do. And these are necessary, and I think that they're good, but there is only so much that we can do. I think that one of the things, I do think there needs to be a revitalization of a culture that makes the argument for the goods of religion, the goods that are secured by religion and the practice of it. I think short of that, we are failing to make an argument for why free exercise of religion ought to be protected.
We have a couple over here.
This may be something that's simple to answer, but as we look at the definition of what religion is, I wonder what that definition is today. What would you call religion?
Oh, you're checking. So this is one of the questions that I was thinking about with the Reynolds case, because one of the ways that it could have been handled, you could say that Mormonism isn't a religion and doesn't deserve the protections under the free exercise clause, but that's not what Waite says. He could have said that, but he doesn't. He adjudicates the case as if this is a legitimate religion deserving of religious freedom protections, but says that there's a compelling interest against that. I think that, so rooting my understanding in something similar to what Story says, I think religion has to be understood here as being the basic Judeo-Christian framework that was prevalent in the minds and the good secured, of the people of that time who adopted the amendment. Yeah, go ahead.
This sort of gives me a chance also to respond to Brandon. I think he's absolutely right with regard to Story and absolutely wrong with regard to the founding. Because the founding was a revolutionary period. They were deeply concerned about liberty. And Madison, book that I've worked on conscience and the Constitution, it becomes very clear that he's deeply concerned about a direct or indirect impact on religion. Now, I think his definition of religion would have been certainly a little broader, but would have still been pretty traditional in terms of this belief in a creator, belief in something like that, a duty that one owes to a being or someone or a creator as a part of their personal faith, and that's how he would define it. And he just didn't think the state had a role in acting in that way. And he actually becomes distressed by what's happening in the early 19th century as you look at what he says later on the topic as well. But it was that notion of a conscience and religious conscience, this sense that he focused on. And I think that's why he used conscience, because he was a little fearful that religion itself might be read too restrictively, and not to include the various kinds of duties one owes to a higher being. There's one right over here. She's been waiting.
Hi, I have a question for Dr. Istook. I don't know if I pronounced your name correctly.
You did fine.
Okay, I'm not quite sure how to articulate this, but for those that think that, you know, with the sexual revolution and in those rights, I feel like the justification for those rights have to come from somewhere. And if they are looking to the Constitution, like what might be things in the Constitution that they could try and justify and change to have that interpretation, other than just like a aberration and broadening of judicial review?
Sure. Well, if you look at the decisions that have been rendered, they typically point to the 14th Amendment, equal protection, which is so broad. Of course, it's been used in a great many decisions to expand the claims of judicial authority. So that is typically what people look to. They don't find some other provision. They talk to the 14th Amendment. Now, when you talk about how do you address it, the essence of the problem is not some automatic conflict between sexual rights and religious rights. It is the effort to proclaim that anyone who disagrees with my provision, on my beliefs on sexual rights, is discriminating, hateful, bigoted, and therefore must be punished for that. That is where the real conflict comes in, where they insist that these rights must be elevated above religious rights in particular. Now, when you talk about how do you address that legislatively, let me just share with you the amendment that I spent years working with a great many people in fashioning the language and getting it where it actually got a vote on the House floor. The language was this: to secure the people's right to acknowledge God according to the dictates of conscience, the people's right to pray and to recognize their religious beliefs, heritage, or traditions on public property, including schools, shall not be infringed. The government shall not require any person to join in prayer or other religious activity, initiate or designate school prayers, or discriminate against religion. Now, the chairman of the Judiciary Committee insisted on adding one more provision, which I'll read to you now. And also, the government shall not deny equal access to a benefit on account of religion. Now, he was the chairman of the Judiciary Committee. I wasn't even on the committee. So, you know, if he wanted something added, it could, although I predicted, and that certainly proved correct, that that would become a lightning rod, because people say, oh, this is just about religion getting money from government, getting benefits from government. I did not want it in there, but it was in there for that reason. But if you notice, the whole thing is cast in talking about the people's right, okay? It's not saying government has a right to impose religion. In fact, it explicitly says government does not. But that does not mean that you must suppress the people from wanting to pray or do something else that acknowledges their beliefs or their religious heritage. And the fact that you're on public property does not add restrictions to your religious exercise. So, and of course, in the affirmative protection, the government shall not require any person to participate in some way. So that was the essence of how I crafted it, to say that we're talking about people's rights. It doesn't use the term conscience, it could have, but that was the approach I took.
Okay, I too have a question for Professor Istook. So the Constitution that we have in this country, you know, it's awesome. I'm a fan, but it's the Constitution, I guess, how do I say this? In the history of the world, it's the longest, like we've gone, I don't know how to word this, but it's the longest written Constitution that we have actually adhered to, if I'm correct in believing that.
It's the longest enduring. It is
Yes,
certainly not the
that's-
longest inwardly.
Thank you.
Far from that.
Thank you.
Yes.
Thank you for that. But I think it's, you know, because of that pattern throughout the world, I think it might be inevitable to have some changes, you know, with things maybe concerning sexual rights and other things like that. Do you think it's possible to create a sort of happy medium where we, you know, include those rights but stay away from restrictions on the rights already stated therein? And if so, what do you think that might be?
Well, that's what I attempted to craft there, all right? It did not infringe on other people's rights. The difficulty is we have people today who interpret, if you have a religious belief that what I'm doing is wrong, you are therefore a hater. And you are harming me by having a religious belief that disagrees with my behavior. That's the underlying essence of the problem. It's not that people are trying to do something that imposes any belief or any behavior on other people. It's saying that because you will not endorse me, you therefore are intolerant, discriminatory, harming me, hateful, bigoted, you know the rest. That's the essence of the problem. Tolerance requires it has to exist on both sides, not just one.
I might give you some constitutional foundation for this, because I have no difficulty, and that would be the 9th and 14th Amendments. The 9th Amendment said if we miss rights, you know, it doesn't mean they don't exist and can't be recognized. And with the 14th Amendment recognizing more of the sort of equality, racial equality, and then racial equality moved into some of the sexual equality area. I do not have difficulty personally with recognizing of that. And what I hope your generation will do is return to more of that revolutionary mindset, the Madisonian sort of mindset, which is let us respect, and it really gets to what Professor Istook just said, let us get to the point where we respect one another's rights, where we realize they come into conflict, and that it's not always best necessarily for the majority in Congress, and then this is something that I sort of disagree with the other two, to decide. I think we need to formulate them as rights and then do the difficult but respectful job of trying to balance them in appropriate ways while showing due respect for all of them.
So I have a question. This is piggybacking off the question of, you know, what is the definition of religion? And in the Reynolds case, famously, there's the example of if a person wanted to sacrifice another person for their religion, we of course wouldn't allow that. It's a very extreme, but very famous example in the case. And so I guess my question is, how do we deal today with religions that are very far outside of the scope that we would consider normal or typical religion, outside the Judeo-Christian value or Judeo-Christian framework, that we might feel are harmful or dangerous, but we cannot prove or disprove the person's firmly held belief or consciously held belief. Something comes to mind, such as Satanism, or beliefs such as that some might see as extremely harmful to the moral fabric of society. How do we deal with that as a people?
Yeah, I'll quickly just take your Satanism example. If you consider Satanism then sort of this sort of higher being, you even get into the Madisonian thing, and so you would respect that. Look, the culture is so powerful. It's not easy to exercise a right like that. I think this parade of horribles that Scalia has, we fought the war in Vietnam and still permitted exemptions based on conscience. One of the things that we seldom recognize is that when someone acts on conscience in contravention to the major culture or to the majority, they are going to suffer significantly in that process. So they're going to pay cost enough, so I wouldn't worry about the parade of horribles.
Go ahead if you.
Well,
I was simply going to say this. If you tolerate Judeo-Christian faiths, that's great. That is not to the exclusion of toleration of other faiths, which could include, it could include Satanism, it can include other things too. But you cannot have a system where you tolerate the lesser supported faiths or fringe faith, as you might choose to call it, and don't tolerate the faith held by the majority. You can't do that, not in a proper system.
my response is pretty simple and straightforward, as I don't really think that my position runs into this particular problem. If it's a valid law and it's neutral and generally applicable, then it would strike down these elements as well.
So, sorry, just as a follow-up, rather than I don't want to offend anyone by saying this, but rather than a fringe religion that is actually believed by its adherents, what about other organizations? Okay, basically, the Church of Scientology has been more active legally and politically than ever it has been religiously. And I do not cast any aspersions on anyone that claims to be a believer of that particular belief system. But from a political point of view, it is a huge troublemaker. And from a religious freedom point of view, it's a huge troublemaker for other religions. Because any judge can point to what they're doing and say, but you see, we can't let religions run rampant. So rather than a parade of horribles or people that believe things that we find abhorrent, what would you say to the challenge of organizations that challenge the legitimacy of what constitutes a religion, but they point to the law and say that they deserve equal protection as well?
I think the legal standard is validly held good faith beliefs. I don't have the exact phrase memorized. It is all too common for faiths to criticize one another. Certainly in Utah, people are well aware that there are many people in the country who do not believe Mormons are Christians or even religious at all right? And that has not been unique in history with one faith disparaging another, all right? So tolerance it has to be broader than that. You have to, if you want to accommodate one faith, you try to accommodate them all. You cannot do it perfectly. You're never going to have, for example, when you place holidays to coincide for obvious convenience of society, that it coincides with certain religious observances, all right? There's no cure for that. That does not mean it's improper. But you still try to do accommodations for multiple beliefs. I know when I was getting this amendment up for a vote in the House and such, I'd have things, and I mentioned, for example, a public school system that had a number of Muslim students, and they allowed the students to go to a particular place to offer their prayers during the day, all right? Or people saying, well, what if someone of a, call it a fringe group, wants to offer a prayer? You take turns, all right? It is not that complicated. It's only those who presume that you are going to be intolerant by being a part of the majoritarian traditions makes you intolerant. It's not so. Not in most cases.
And I'll just sort of try and tie things together because we're going to try and get to the other. Again, I'm not really fearful of Scientology. I think there is difficult work to be done. I do generally trust the courts better than I do the majority, who have a tendency, a propensity to tyrannize, to make those kinds of determinations, whether it be a religion or not. But if you're a religion, then you're also going to be subject to the Establishment Clause. So if you're the Green Party and you want to commandeer government, you don't want to be a religion, because you want to be free. You don't want those liabilities. The other thing is, remember the cost that people pay. And one quick note on this neutral general and the notion that, oh, but we can then let legislatures make exemptions. Well, who's the majority going to exempt? They're not going to create a law that's going to go against anything close to the majority. They'll exempt them regularly. So I just think we want to, and I don't even care for the language tolerate. That's a 17th century notion. We need to respect one another in our differences and realize what Warren said, that liberty, and what Madison said, liberty is the light we ought to shine on the world.
I'm going to have to be the bad guy here and mention that our next panel starts in less than 5 minutes here. It's a student essay contest, but please join me in thanking our panelists for a good start to the day for the conference.